We're going to get started because we have an incredibly wonderful panel today and a lot of interesting things to talk about, and I know we don't want to lose a minute. I would love to welcome you today to ACS's annual Supreme Court preview. I'm Caroline Fredrickson. I'm the president of the American Constitution Society. I'm very glad to be with you today. I have to say, I just came back from the south of France, and I do mean it. I really am so happy to come back and be able to be here at this is one of the best events we do, and we do, I think, as so many of you know, an incredible number of wonderful events throughout the year. But our Supreme Court preview may be our most anticipated and most informative. So I'm so glad that you're all here and that I'm here as well. So I think you probably are all familiar with ACS. I certainly hope you are, but just in case, a quick overview. We were founded in 2001. And we are a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping the debate on vitally important legal and constitutional issues such as the ones we will discuss today. So I think we all know that in the past several terms, the Supreme Court has had quite a number of blockbuster decisions. And it's hard to know if there'll be another term like those, but we certainly are anticipating a number of important cases on the court's docket for this year as well. Among those that we are watching, the Supreme Court has taken a new pair of voting rights cases, which are challenges to the state of Alabama's legislative redistricting plans on the grounds that they purposefully dilute the votes of African Americans. The court will also look at threats posted on Facebook under the First Amendment, and it will referee a dispute between the executive branch and Congress over the status of Jerusalem. And when the justices gather for their September 29th conference, they will have before them 7 petitions regarding state same-sex marriage bans, increasing the likelihood that we will have the question of marriage equality squarely before the court this term. To lead us through the discussion today with our very distinguished panel, we have a true expert on the Supreme Court, Jeffrey Rosen. Jeff is the president and CEO of the National Constitution Center, the only institution in America chartered by Congress to, quote, disseminate information about the United States Constitution on a nonpartisan basis. And I highly commend to all of you, if you have not yet been there, you should take a visit to Philadelphia and see. It's an incredible institution. Jeff is also a professor at the Washington University Law School and is a highly regarded journalist whose essays and commentaries have appeared in the New Republic, where he is the legal affairs editor, the New York Times Magazine, and in the New Yorker, where he has been a staff writer. He's the author of several books, most recently Constitution 3.0, Freedom and Technological Change, books about Supreme Court Justice Louis Brandeis and President William Howard Taft are forthcoming books. Wow. And we look forward to reading them. So, wow. So please join me in welcoming Jeff Rosen.
Thank you so much, Caroline. It's so wonderful to be here with my great friends at ACS and to bring you greetings from the National Constitution Center. I love the fact that Caroline quoted our inspiring congressional mandate. We are a private nonprofit, but we are indeed the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And that means that not only are we a spectacular museum of We the People on Independence Mall in Philadelphia, right across Independence Hall, where starting in October, we're going to display one of the 12 original copies of the Bill of Rights, which you have to all come see. But we're also America's town hall, and every week and every day we are uniting the best thinkers in America from the left and the right and everywhere in between to debate not political issues, but constitutional issues and let citizens make up their own mind. And please listen to our exciting We the People constitutional podcasts, where every week scholars representing ACS and the Federalist Society are getting together to talk about the constitutional issue of the week. And these podcasts are getting up to 200,000 downloads a week. You can hear Jeffrey Stone against Richard Epstein on affirmative action and so forth. And really, there's no other place, you laugh, but it's an amazing podcast. And some great stuff emerged. And really, there's no other place in America that believes that if you bring together both sides to discuss the Constitution, some clarity, if not common ground, may emerge. So it's a really thrilling place, and I hope you'll visit us online and in Philadelphia. This is a dream team panel. We've got an exciting Supreme Court term. We have a lot of important and complicated cases to discuss, so we are going to jump right in, and we're going to talk about the major cases that Caroline discussed, and then we'll talk about the broader cases that may be on the horizon, including marriage equality and some of the the ACA cases, well, which of course you hope will end up decided as ACS cases, but that remains to be seen. And more broadly, I also want to tease out the general question, is this the 5-4 ideological court, or is it the Roberts unanimous court? Last term, the court had a higher rate of unanimous decisions than at any time since the 1930s. 66% of the decisions were unanimous. And these included important cases like that inspiring cell phone cases. Wasn't that a thrill to see all 9 justices agree that warrantless searches of our cell phones on arrest are equivalent to the general warrants that sparked the American Revolution and that inflamed the patriots who drafted our Constitution. And there was also unanimity in cases involving recess appointments and abortion bubble protest zones and other important cases. At the same time, we saw the familiar lineup of 5-4 cases in such blockbusters as the Hobby Lobby case, which was so controversial that Justice Ginsburg accused her male colleagues of having a blind spot when it came to issues of women's equality and reproductive choice. And there were vigorous dissenting opinions about the follow-up to Hobby Lobby. So I'm going to ask our distinguished panelists, which is it? We know that when Chief Justice John Roberts took office, he pledged to be a uniter, not a divider, to try to encourage his colleagues to converge around narrow, unanimous opinions rather than allowing them to divide along familiar ideological lines. He said it would be good for the court and good for the country in these polarized times for there to be one branch of government that transcended politics. And in his historic vote in the Affordable Care Act decision, Chief Justice Roberts seemed to be fulfilling this vision of putting the institutional legitimacy of the court above ideological purity. And this term, I want to ask our colleagues, why was it that he had so much success? Was this his own leadership powers? Was it the buy-in of his colleagues, his liberal colleagues, who were more interested in forging consensuses? Or is this a false unanimity? And do cases like the recess appointments case, which is formally unanimous, conceal genuine divisions among the justices about the reasons? And should we expect to see more divisions coming up? All right, so lots to discuss. Brief introductions, because you have the bios of these phenomenal panelists. I'm going to take them in alphabetical order. Just so briefly, Gregory Garre, currently a partner in the DC office of Latham and Watkins, served as the 44th Solicitor General of the United States between 2008 and 2009, and he argued then and argues now with great distinction. Martin Lederman is Associate Professor of Law at Georgetown University Law Center and was Deputy Assistant Attorney General in the Department of Justice's Office of Legal Counsel from 2009 to 2010. Bill Marshall is currently the Kenan Professor of Law at the University of North Carolina and was Deputy White House Counsel and Deputy Assistant to the President during the Clinton administration. Emily Martin is Vice President and General Counsel at the National Women's Law Center, and Janai Nelson is Associate Director-Counsel of the NAACP Legal Defense and Education Fund. We have agreed about a rough division of cases. Each of the panelists is going to begin by teeing up one important case. The others will discuss, and then we'll turn to the broader issues. I'm going to begin with I guess I shouldn't confess this, but this is my favorite case because I'm such a junkie of free speech on the internet. And the Alanis case raises the question of free speech in the age of Facebook. We live in an age when lawyers at Google and Facebook have more power over who can speak and who can be heard than any king or president or Supreme Court justice. And the decisions of these lawyers about when and whether to remove material that is considered a threat defines our jurisprudence. And yet the court is about to hear its first free speech threat case of the internet age and decide whether a subjective intent to threaten is necessary for the speech not to be protected under the First Amendment. These were horrifically offensive Facebook posts that Bill Marshall will tell us about. And I'd love Bill to both give us a sense of the case, what were the facts, what's the legal issue about whether subjective intent is required, and then reflect about the difference between the First Amendment standard and Facebook's own standards. I just looked around on the Facebook website, and it turns out Facebook has its own test for deciding whether a threat is credible. That includes whether there are signs of credibility. Does the post mention a time, a place, a method, identify the intended victim? In other words, the Facebook lawyers in deciding whether to leave up posts are trying to figure out whether it's credible. The First Amendment lawyers, it seems, have to ask whether a reasonable person would consider the threat to be genuine, and I'm interested in Bill's thoughts about the difference between those two standards. So Bill, take it away on Alanis.
One of the great experiences of being on a panel like this is a great distinguished group, and I want to thank ACS for inviting me to participate. And the other thing is it's the sensitivity to what it's like to be a law student as opposed to a law professor, because I get called on cold and I have to respond to things that I may not have thought about. But let me begin and try to do that. Anyway, this is an interesting case, Elonis, for a lot of the reasons that Jeff outlined. Mr. Elonis, I think it's fair to say, is not a happy person. His wife left him, he lost his job, and he started posting a number of things on Facebook, including language that looked like it was threatening to his wife. He said, it's illegal for me to say that I want to kill my wife. And he used language and lyrics similar to what Eminem uses. In fact, one of the interesting things about the lower court opinion is quite a discussion of Eminem. So there's a lot of popular culture in this case. The FBI investigated this, and somebody came to the door, and his response to that was to say he wanted to slit the throat of the FBI agent, and then just to add a few other good measures, he threw in some language about wanting to shoot up a school. And the question is, he's prosecuted under threats for making a threat which is illegal under federal law. And there are two issues in the case. The one that I think the court's going to decide on is the statutory construction issue. Yes, I know, dull, not First Amendment. But there is a First Amendment. There are clearly lots of First Amendment issues that are in the background here. Threats, as a general rule, when the court decides a First Amendment case, it doesn't decide that everything is automatically entitled to First Amendment protection. There are various categories of speech, obscenity being one, that are deemed not to be entitled to free speech rights. True threats, what are called true threats, are one of those kinds of areas of speech. And so if Elonis can be said that what he was doing was a true threat, then he is not going to be entitled to First Amendment protection under the First Amendment. At the same time, the court recognized that a famous case dealing with a threat on the President of the United States, then LBJ, where somebody said, if I get a gun, the first thing I want to do is shoot the President. And the court held in that case, well, yeah, real threats are not protected under the First Amendment, but we also have to distinguish between hyperbole and an actual threat. And in that case, the court protected the speech involved, saying nobody would really deem it to be an actual threat. It was more in the nature of hyperbole. Okay, fast forward to Elonis. What was interesting in that case is that the court didn't say, and the jury didn't find apparently, that these statements were hyperbolic. The court and the jury took these statements seriously and found that the statements that he put on his Facebook page, and let me point out here as a factual matter, these Facebook pages, these were not direct communications to the FBI. They were not direct communications to his wife. There's good reasons to assume that Elonis knew his wife was going to be looking at his Facebook page. And there's certainly good reasons to know that the FBI was looking at his Facebook page, because after all, they knocked on his door. Whether people from various schools were looking at his Facebook page are unclear. But in any event, these were not directed threats in the same way that, say, for example, saying it to the person directly or sending them a letter might be a direct threat. It was posted on a Facebook page. The jury found in this case that what he said on his Facebook page, that he intended to say it, and that the person reading this thing would feel reasonably that this was a reasonable threat. What Elonis is arguing on appeal is that it's not enough that somebody could perceive this as a threat. What they have to show in order to convict him is that he intended it as a threat. That is, it's not just taking a look at the language, it's not how the receiver would perceive it, it's whether the person intended it. So when somebody puts up on the lyrics, "I want to slit their throat," it's whether he was really making a threat to slit somebody's throat, whether he intended that, or whether the person who is the victim of that threat feels that it's an actual threat. And that's the difference in the case. That is the narrow legal issue in the case as to whether or not subjective intent is going to have to be shown. All right, now let's put this what the court is likely to do. I make Supreme Court predictions all the time. I get them wrong 99% of the time as to how they're going to come out. This one I think is going to be, this one I'm going to predict 9-0 that he's going to get off. And he's going to get off on the statutory claim that the court probably won't reach the First Amendment claim, and they will require that it's necessary to show that he intended to threat, not just that his speech might be perceived as a threat. Now, why do I say this? I say this not just as a matter of statutory construction, but here's where the First Amendment comes in. The First Amendment comes in because I think it's going to influence how the court's going to decide this case. And this court has been very interesting when it comes to fringe speech. It protected crush videos, which, for those of you who are not familiar with the Stevens case, or when pornographic videos of people sticking high heels into animals, which apparently some people find to be interesting. There was an anti-animal cruelty statute that went on against the showing of this. You could obviously penalize somebody for the act, but this penalized the dissemination of a video on that. The court struck that down. In the Brown case, the court struck down restrictions on violent video games. And in the most famous case of all, Phelps versus Snyder, the court overturned a decision against the Westboro Baptist Church dealing with an intentional infliction of emotional distress on the father of a fallen soldier when the Westboro Baptist Church went to the funeral and did their thing, and their various kinds of messages, despicable messages that they tend to show. So this court is very interested. It has protected fringe speech. Even in the cross-burning case, where it upheld the statute prohibiting cross-burning, it overturned the specific conviction in that case on a relatively narrow ground as to whether or not intent could be presumed by the act of cross-burning. So I think that we've seen here a very protective court with respect to this kind of fringe speech. The other thing that's coming together with this case is it's falling from another line of cases that have nothing to do with speech, and that are the cases dealing with the GPS search from a couple of years ago and from the cell phone search from last year, in which the court, for the first time, give it credit, is starting to try to really wrestle with changes in modern technology and how that affects law. Now, generally, the court doesn't say the medium affects how much First Amendment protection that you have. But the court is also looking at the context, and the context of social media these days, and the context of rap music these days, suggests that what Elonis put out there really isn't all that unusual for what's going on Facebook and what's going on in popular culture. So I think the court is going to be very predisposed to protecting this speech one way or another, and the easy way, the narrowest grounds that it can do that is to come up with the requirement that in order to convict the defendant, you also have to show the intent to threaten and not merely the objective view that somebody might be threatened. So my guess is it's not going to be a First Amendment case. The court may not have the room to decide that this is pure hyperbole, although it would have liked to have gone there, given the circumstances. I think that what they'll do is just take a look at this very narrow statutory decision as to how it decides the case. Now, Jeff asked a follow-up question on Google and what Google looks at. Now, first of all, one of the great misconceived notions of the First Amendment, and I want to make this clear, you all know this, but I need to repeat it anyway, my students get this wrong all the time, is that the First Amendment requires state action. It means that the government must be acting. So when the argument came out a little while ago that somehow the Arts and Entertainment Network violated the First Amendment right of Duck Dynasty because it censored Phil Robertson, that's not true, because there's no First Amendment right there against the Arts and Entertainment Network. There's no First Amendment right against Google because Google is a private company. So Google can impose greater restrictions on the speech that it shows, that it allows to be demonstrated on its website than the government can in terms of allowing speech generally. With respect to Google's requirement, I think they can add what they want to add if that's how the way they want to, if that's how they want to regulate their own trafficking. You know, the problem with threats, as the court points out, is that the reason why we protect against threats are because of the psychological harm felt by the receiver, which is a legitimate concern. Part of the problem with respect to the internet, of course, is that the distance and the ease that you get for getting widespread dissemination, it's so vast, it's so permanent, that our law has really not been able to deal with how serious whatever psychological harm is felt by that. And there are two ways of looking at it. One is that the psychological harm is incredibly deep because you know so many people are seeing it, because it's so much of a part of daily life. It's not like a threat that is made personally and then disappears. And the other way is that we're becoming so used to this stuff on the internet that it's shielded us, and we don't take most of the communication that we see on the internet seriously. And how Google and how other forces in society want to deal with that, I think, is an interesting, broader question. With respect to this case is going to get a lot of attention precisely because it is Facebook, precisely because the facts are extraordinarily colorful, but at the end, it might end on a relatively narrow issue of statutory construction.
Thank you so much, Bill, for that extremely thoughtful analysis. I'm curious, Greg, if you don't mind my asking, do you agree with Bill that the court will impose a subjective intent requirement? Judge Sirica below pointed out that no lower court had done so, and the reason that Facebook doesn't do so is because in a world where fantasy and reality is blurred, they think it's hard to figure out what subjective intent is, which is why they look for objective indicia of credibility. What do you think is going to happen?
I would begin by saying I think Judge Sirica's opinion was very thoughtful and very careful, and I could say it as a former Judge Sirica clerk.
Oh, good. Excellent.
I do tend to agree with Bill that I think this is an area where the court is going to want to move instinctively, very cautiously, very moderately, very incrementally, and the statutory option, which the court presented to itself by adding the question at the certiorari stage, may well be attractive to it. It may be one of those options that will bring together more justices on the court, so sort of provide some of that unanimity that they were able to find last term, and that would be attractive in itself. I guess the one thing that I react to a little bit differently is reading the actual threats in this case. I mean, to me, they struck me as, pretty alarming. I mean, you sort of tick the main boxes: domestic violence, violence against children at school, violence against federal officers, and I wouldn't be surprised if they struck the justices as very problematic and not something that they would either be accustomed to on their Facebook postings if they post on Facebook, or even assumed was part of ordinary conversations over the internet. So I think that will trouble them, but they may well also conclude that if they do impose this subjective intent requirement, that the evidence is so overwhelming in this case, that ultimately the government will be able to present that argument on remand.
Oh, that's great. Now, I think none of the justices do, in fact, post on Facebook, although we do have some lower court judges who tweet. Our next case, I'll just go down the line. Emily, there is an important case involving the Pregnancy Discrimination Act. It's called Young versus United Parcel Service. The issue is in what circumstances the Pregnancy Discrimination Act requires an employer that provides work accommodations to non-pregnant employees with work limitations to provide work accommodations to pregnant employees who are similar in their ability or inability to work. Gosh, pregnancy discrimination has given rise to some of the most interesting challenges in gender discrimination. There's this Geduldig case on the books that says that there's no gender discrimination when it comes to pregnancy because it's a distinction between pregnant women and non-pregnant persons, which Justice Ginsburg and others have objected to. So tell us about the stakes in Young. Will it be decided broadly or narrowly, and what might the implications be?
Sure. So Young versus UPS is Peggy Young's case. Peggy Young was a UPS driver. She did airmail delivery, which meant that most of the deliveries she did were actually envelopes, fairly light things, but her job description said she had to be able to lift up to 70 pounds. And when she became pregnant, her medical provider recommended that she avoid lifting more than 20 pounds during her pregnancy. So she told UPS that and said, I'm comfortable continuing to do my current job. I hardly ever have to lift more than 20 pounds. Or you can put me on light duty. That would be fine, too. She assumed that that was an option because UPS provided light duty to employees with on-the-job injuries and employees with disabilities under the ADA, and employees who had lost or who weren't able to get a commercial driver's license for medical reasons or other reasons, such as having a DUI conviction. All those people were eligible and received light duty, including people who had lifting restrictions very much like her own. But UPS said, no, we don't do that for pregnancy, and you also can't do your current job anymore. You're too much of a liability risk, given that you had this lifting restriction. And so instead, they forced her out into unpaid leave, and she lost her health insurance benefits. Now, the Pregnancy Discrimination Act, which was passed in 1978, seems to address this issue fairly directly. It says that sex discrimination includes pregnancy discrimination, and it also says that employers must treat workers affected by pregnancy the same as it treats those who are not so affected, but who are similar in ability or inability to work. That's the exact language. So seems to say that what the employer should do is look at how it's treating others with non-pregnancy work-related restrictions and then treat the pregnant worker just as well. And Congress adopted the Pregnancy Discrimination Act in response to Gilbert versus General Electric, which was the case following the Geduldig decision that Jeff just mentioned, where the court again said, under Title VII, Geduldig was constitutional, that yes, sex discrimination is not pregnancy discrimination. Pregnancy discrimination is a whole different thing. The Gilbert case was a case where an employer provided a temporary disability insurance policy that covered everything but pregnancy. And the Supreme Court said perfectly fine to decide what risks you're going to cover and what risks you aren't going to cover. Pregnancy is different from diseases and injuries, and the employer can make that decision. Congress reacted very quickly in passing the Pregnancy Discrimination Act within 2 years to reject that holding and that analysis. And the language in the Pregnancy Discrimination Act saying you have to treat pregnant workers the same as you treat those similar inability or inability to work was specifically responding to the Gilbert Court and its decision that it was fine to treat disabilities arising out of injury or illness differently from disabilities arising out of pregnancy. Despite all that, the Fourth Circuit, when it considered Peggy Young's case, ruled against her. The Fourth Circuit said, well, despite what the actual language of the Pregnancy Discrimination Act seems to say, and the circuit said, and on its face that language is unambiguous, we don't really believe it means that. The Fourth Circuit said the rules that UPS has are pregnancy blind rules. The Fourth Circuit said Peggy Young didn't have an on-the-job injury, And she didn't have an ADA qualifying disability, and she hadn't lost her commercial driver's license, so she didn't fit in any of these categories. And unless she can prove that UPS adopted those rules with the specific intent of harming pregnant women, that they were motivated by animus against pregnancy, then she loses. So the question for the court is basically whether that's right and what the language in the Pregnancy Discrimination Act means when it says you have to treat pregnant workers the same as you treat those who are similar in ability or inability to work. And it's an important case because Peggy Young's story is not unique. Lots of women with some sort of work limitation arising out of pregnancy face similar issues, especially women in low-wage jobs that are often more physically demanding, like retail work, for example, or in traditionally male occupations, like Peggy Young, who was a truck driver. Often these women, when they seek some sort of temporary change in the job because of pregnancy, even when their employers routinely provide those changes for non-pregnancy related disabilities or for on-the-job injuries, often those women are told, no, sorry, if you can't do the job, you're out of here. And they have to decide whether to continue doing the tasks that their medical providers have advised that they avoid, possibly endangering their health, or whether they're going to lose their paycheck at a moment that they can least afford it. And the case is also important because it's sort of the next chapter in the Supreme Court thinking about issues of women's equality and women's reproductive health after the Hobby Lobby decision last term. And it's sort of interesting. In McCullen, the court was fine with struck down a law that sought to protect women's ability to seek abortions. In Hobby Lobby, the court put up barriers to women seeking contraception. And so here are the cases, so what if you're pregnant? What then? Are you also going to face the risk that you can be forced off of the job? I think it's an interesting question for this court, given the clear text of Title VII and the Pregnancy Discrimination Act and what it does seem to require here, as the Fourth Circuit acknowledged, which poses the interesting question of whether you'll see the 5-4 divide that we've often seen in Title VII cases and in sex discrimination cases with the passionate Ginsburg dissent, or whether justices who purport to put a great deal of stock in the plain language of a statutory text in analyzing what the statute requires, do that here. And it's an interesting case also because it's brought together some sort of unusual bedfellows in support of Peggy Young. The briefs in support of Peggy Young were filed last week. And there were the women's rights groups that you would expect, like mine, on the case. There were also bipartisan state and local legislators, Democrats and Republicans, saying that accommodating pregnancy just makes sense, that in their state they had passed laws making sure that employers were going to be able to do this, and that they believe the Pregnancy Discrimination Act required this as well. There was also a brief filed by a large number of pro-life organizations saying that the Pregnancy Discrimination Act requires this clearly by its terms, that this is part of respecting pregnancy, that respecting women is part of respecting life, which was interesting. So I think it's a case that's going to attract a lot of attention because the facts of the case are readily understandable, whether you're an attorney or not, and I think emotionally compelling to a lot of people. And I think that the situation in which Peggy Young found herself, where she lost her income at the moment she was expecting a baby, and the other women find themselves in where they have to decide whether they're going to continue to do a job that may be endangering them in some way or whether they're going to lose their job, that's an issue that a lot of people understand and can relate to. So I certainly hope that the case goes in Peggy Young. So I find it hard to predict, though, frankly, given the various competing factors at play.
If a 5-4 split were to be avoided, would it be on textualist grounds, or would the court look at the intent of the Pregnancy Discrimination Act, and who would write the opinion?
Well, those are all hard questions to answer, aren't they? I think that legislative history also supports Peggy Young, that Congress, again, had as a primary motivating factor when it passed the Pregnancy Discrimination Act a desire to ensure that pregnancy was treated as well as employers treated other disabilities, and that's sort of the key issue in this case. Now, admittedly, the difficult issue in this case is that there were non-pregnant employees with some sorts of work restrictions who weren't accommodated too. So the question is, which side of the line do you compare the pregnant worker to? The side of those people similar in ability to work who were accommodated, or those people similar in ability to work who were not accommodated? And I think that one could say the language does not provide an absolutely clear answer to that question, though I think that the intent of the Pregnancy Discrimination Act in seeking to remove obstacles that had long pushed pregnant workers off the job with real financial impacts for them and their family, often based on stereotypes about the incompatibility of motherhood and work, that intent supports the notion that if an employer has chosen to, is able to provide accommodations for other similar limitations, that the employer has to provide those limitations for pregnancy, provide those accommodations for limitations arising out of pregnancy too. That's part of the remedial purpose of the Pregnancy Discrimination Act in ensuring that pregnancy can no longer be treated as sort of as a second-class condition, that pregnant workers are no longer second-class citizens in the workplace.
Great. Thanks so much for that. Our next blockbuster case is Zivotofsky versus Kerry. The issue, whether a federal statute that directs the Secretary of State on request to record the birthplace of an American citizen born in Jerusalem as born in Israel is unconstitutional on the grounds that the statute impermissibly infringes on the president's exercise of the recognition power reposing exclusively in him. We have a world expert on executive power. Take it away, Marty Lederman.
Thanks, Jeff, and thanks to ACS. It's always a pleasure to be here, especially with panelists like this and an audience of such friends. And Zivotofsky is an interesting case. It's the second time the court is confronting this case. The first time was not on the merits. I'll discuss that in a second. And it's a really unusual case. It's a somewhat arcane issue. It's the second time in two terms in which the court is confronting a separation of powers question that had really never come before the court for over 200 years, that had been worked out by the political branches for all that time, and now all of a sudden the court has to referee a dispute between the branches without any obvious guideposts on how to resolve that question. So, as Jeff suggested, the case arises out of an age-old dispute between the political branches about how the United States should formally treat Jerusalem. Should it treat it as being Israel's property, the sovereignty of Israel, or as the executive branch has treated it since Israel's independence, as being an open question. The United States has formally, at least as far as the executive branch is concerned, for over 60 years, treated the sovereignty of Jerusalem as an open question that should be and is subject to negotiations between Palestinians and Israel, and that is a very difficult nut to crack, obviously, in any such negotiations. It will be one of the hardest issues to resolve that the parties need to resolve in order to reach any sort of lasting peace. Therefore, the United States has tried to stay agnostic on that question, or at least the executive branch has. This hasn't sat well with many in Congress for many decades, so Congress has, over a number of years, tried to, and occasionally successfully, passed legislation trying to push the United States, or to actually require the United States, to treat Jerusalem as being within Israel's sovereign territory. For instance, the Congress has passed statutes forbidding the executive branch to use any funds to build an embassy or to use an embassy in Tel Aviv, which is what the United States has done, thereby trying to exert pressure on the executive branch to put an embassy in Jerusalem, which would have, according to the executive branch, profoundly deleterious effects on the ability of the United States to be the broker between the parties for Middle East peace. In 2002, and I'll offer a caveat here, I was working in the government in 2002 and then again in 2009 and 2010, in both of which contexts I dealt with this question. Nothing I'm going to say here reflects the views of the United States or even my own views, I don't think. I will give some thoughts about the case, but you shouldn't, none of this reflects any confidential information or the views of the United States. Congress passed as part of an appropriations law. It was the Foreign Relations, actually an authorization law, the Foreign Relations Authorization Act for the fiscal year 2003. One section of it, section 214, was entitled United States Policy with Respect to Jerusalem as the Capital of Israel. That's the title of the section, and the section had 4 parts to it. Some of them are merely hortatory, for instance, urging the president to immediately begin the process of relocating the embassy to Jerusalem. Another interesting one that hasn't gotten any attention states that the executive branch cannot use any appropriated funds for publication of any government document, like an atlas or an official State Department Foreign Relations manual, that lists countries and their capital cities, right? Think about your high school textbook, unless that publication identifies Jerusalem as the capital of Israel. That provision is not technically before the court here, but it's part of this law. The provision that is before the court is 214 sub D, and that's about passports. A very weird little fill-up to this effort by Congress over the years to try to change the U.S. policy toward Jerusalem. It provides that for purposes of the registration of birth, certificate of nationality, or issuance of a passport of a U.S. citizen born in Jerusalem, the Secretary of State shall, upon the request of the citizen or his or her legal guardian, record the place of birth as Israel. So what this says is, now let me back up. The State Department's policy with respect to passports for decades has been that if you are a U.S. citizen born in Jerusalem, our passports give a place of birth. I'll give a place of birth. I'll explain why in a second. If you were born in Jerusalem, the passport shall simply say Jerusalem without stating a nationality on the U.S. passport in the service of this long-standing executive branch view that the U.S. should be agnostic or neutral as to where Jerusalem is or ought to be. So generally speaking, most U.S. citizens born in Jerusalem, their passports simply say Jerusalem. Now the purpose of this identification on a passport, according to the record, the principal purpose is to both identify, is basically to tell the people reading your passport who you are and to make sure that they can look up their records and say, oh, this is the Joe Smith who was born in Paris or in France, not the one born in Singapore, or whatever the case may be. It's an identifier principally used by U.S. officials overseas to try to figure out, okay, which person bearing this name, which U.S. citizen is this? The place of birth is a narrowing identifier, but it's also read, of course, by the customs official or whoever looks at your passport when you get there, although they don't use it for any particular purpose most of the time. So what this statute does is it says, if you want to, if you are a citizen born in Jerusalem, and if you so choose, your passport may say instead, Israel. Not even Jerusalem, Israel, but just Israel. And Binyamin Zivotofsky was a young man born in Jerusalem to U.S. citizens who now is a U.S. citizen, and his parents decided they wanted his passport to read, pursuant to this statute, they wanted it to read Israel. They want that to be how they convey the place of birth of their son to whoever reads the passport from this day forward. And this statute appears to require the Secretary of State to put down the word Israel on Binyamin Zivotofsky's passport. President Bush, when he signed the bill, said it should be construed not to require the Secretary of State to do this. That view was rejected by the Obama administration that concluded that, no, you really have to read the statute to mean what it says. This is a requirement, but President Bush was right about one thing. If it is a requirement, it's unconstitutional, and therefore we are not going to enforce it. So this is a case, a rare case, but these cases come up, in which the executive branch is refusing to enforce a statute of Congress on the ground that it is unconstitutional. Zivotofsky sues the Secretary of State. I want the word Israel put on my passport. Secretary of State says no, a position supported by both Republican and Democratic administrations alike. So the question is, who wins, Congress and Zivotofsky, or the executive branch? Who gets to decide this question? I have to say so it went to the court. First, the government argued that it was a political question. Many of you may know what that is. A political question is a category of cases very rarely invoked. It's discussed all the time in law schools because it's so interesting, but the court actually rarely invokes it. But there's a small category of cases which the court holds, we're not going to decide the merits of a question because either the Constitution assigns that question to another actor, the Senate, the President, some other actor, or because it doesn't admit of any judicially enforceable standards. There's nothing we can latch onto that would give us a way of resolving the question. The government argued that this was that sort of question. You should let the president and the executive branch and the Congress fight it out, and whoever wins in politics and in the back and forth, that's how it should be resolved. The court rejected that view 8-1. They said, this isn't a political question, this is susceptible of judicial resolution, sent it back to the lower court for judicial resolution, and the DC Circuit held that the executive was right, that the executive doesn't have to enforce this statute, that the word Jerusalem can continue to appear on Zivotofsky's passport. It's back up at the Supreme Court now, where I think many of the justices might regret saying that they could resolve the merits, because the text doesn't tell you very much. Text of the Constitution has very little, if anything, to say about this. There's no judicial precedent on it. The history of the relations between the branches on these questions is, as the briefs demonstrate, very complicated and contradictory and woolly and not susceptible of any clear answer, I think it's fair to say. It's been a dynamic engagement between the branches for over 200 years on these questions. Sometimes Congress wins, sometimes the president. They often reach a compromise on such disputes about recognition and the like. And I think many of the justices will think that neither side here has a very good case. Like, who cares, right? Right? So on the one hand, the government comes in and says, but this will be what this statute does is it makes the United States recognize Israel as being part of, Jerusalem as part of Israel, and Zivotofsky comes in and says, and so does the Senate, no, it doesn't. It just says this word has to be on a passport. It doesn't affect the official United States view of which nation Jerusalem belongs to. It's a mere passport regulation. And so therefore it doesn't really impinge upon any prerogatives of the president, even if you think the president has those prerogatives and they can't be cut back on or regulated by Congress. On the other hand, what's Congress doing, right? It's not as if, on that view, Congress isn't even taking a position on where Jerusalem ought to be. It's merely giving individual U.S. citizens the right to speak on their passports to what audience, right? Like, wear a sign saying, I was born in Israel. Nothing's preventing you from saying, I was born in Israel. Why should you get to use the U.S. passport to do it? It seems to be a use of the passport power that's totally unrelated to the reasons Congress was given that power. So it seems like a pox on both your houses kind of case, that no one really cares about what appears on this guy's passport or that it could make a constitutional difference. But here's what's really interesting about the case, I think. What I think will become clear, if it's not already to the justices, is it's not really about the passports. So when you think about it, I read you the law. The law says, it's in the U.S. Code, a law passed by the United States Congress, signed by the president, says, United States policy that Jerusalem is part of Israel. Hasn't the damage already been done, right? Isn't that much more of an effect on the world's view of U.S. policy than what's on somebody's passport that nobody ever sees? The government's response to that is, yeah, that was a problem. It was a bad thing that Congress passed that statute, but we fixed the international diplomatic ramifications by pushing back and saying it was unconstitutional and we weren't going to enforce it. So we've basically created the equilibrium again where in the Middle East everyone agrees that we are agnostic. But if and when this court holds in favor of Zivotofsky, it will be not the passport, but the court's opinion on June 21st, 2015, that will have these convulsive foreign affairs effects. The headline in the Middle East will be, court rules with fill in the blank, either the president or Congress. And if it says the court sides with Congress, no matter what the court writes in its opinion, viewers overseas will see that as the United States reneging on this neutrality that it has tried to abide by for 60 years. And I think the justices will be really, really nervous about sending that signal to the world and upsetting Middle Eastern politics. On the other hand, what's the alternative, right? The alternative is, the headline is, court sides with the United States, right? And that will upset other parties in the Middle East, not to mention here in the United States. So I don't think any of the justices is going to relish resolving this question. And I'll leave it at that. I'm curious what my fellow panelists, how they think the court will resolve the question.
Thank you for that very thoughtful analysis. Bill, how will the court resolve the question?
Well, I think Marty did a terrific job. I think the court right now is regretting the political question decision. There's no doubt about it. I will say Marty and I talked earlier, and he said that what the court should do, in its opinion, is put in capital letters, do not take this opinion as a statement of American foreign policy when they actually issue the opinion, which I think is a great idea.
But it's unclear whether the media outlets in the Middle East will treat it.
Yes, that's right. That's right. Whether that'll work or not, I don't know. I mean, I do think that it's a big fight over nothing that can cause a lot of problems down the way, as to whichever way they resolve it. So I think Marty's dead on in the way that he describes it. It's also part of the problem that we're seeing, by the way, with signing statements. You know, when you sign a statement and sign something that you think is unconstitutional or you think is problematic, or you try to work your way around it, you might have to live with it at a later point in history.
Janai, there are two important redistricting cases out of Alabama, and there are many interesting things that we want to hear about them, but one of them is that this is under Section 2 of the Voting Rights Act, which is one that we hadn't heard so much about in the past couple of years. There were all of these cases, from Shaw v. Reno, 1993, to Hunt and Cromartie, 2001. I used to teach them. The question was, do states have to create majority-minority districts in the face of racially polarized block voting? And the court comes up to the brink of striking down Section 2 as being unconstitutional racial gerrymandering, but then steps back from that brink by saying, if you're doing it on the basis of political affiliation, not race, it's okay. But then things kind of died down for a while, and all the action was under Section 5 of the Voting Rights Act. We had the big Shelby County case last year. But Section 2 is back, partly because of the 2010 census, where Alabama had to redraw its majority-minority district. Tell us about the stakes in these two fascinating cases and what the court might do.
Thanks for that intro. Well, each term, the court, at least in recent years, has had a very interesting election law case. Last year it was FEC, McCutcheon versus FEC, and before that, Shelby County, the case you just referenced. And this year it could be the consolidated cases of Alabama Democratic Conference versus Alabama, or the Alabama Black Legislative Caucus versus Alabama. Those two cases have been consolidated into one redistricting battle that has reached the Supreme Court. So let me just give you a little background about how this case came to be. So as Jeff just mentioned, this follows the 2010 census and the redistricting, the 2012 redistricting that occurred as a result. This redistricting was led by a Republican-dominated legislature in Alabama, and effectively what that legislature did was maintain the same percentages in majority-minority districts as they existed in the 2000 plan. So when the 2000 census came out and that plan was redistricted based on those numbers, there were majority-minority districts created. Fast forward 10 years, the Republican-led legislature is redistricting again and maintains the same black population percentages in these majority-minority districts. On its face, that doesn't sound terribly controversial, right? It sounds, nothing is terribly preposterous to continue the same sort of percentages on its face. But if you think about what the standards are governing majority-minority districts, then you begin to question what the motivations are. So and you alluded to the two different provisions of the Voting Rights Act that are key here. We have Section 2, which requires that there be no vote dilution of minorities' voting power, meaning that minority voters have to maintain an opportunity to elect candidates of choice, and that there can be no infringement by states or other actors on that right. And then you also have Section 5. Now, Section 5 of the Voting Rights Act was gutted 2 terms ago in a case called Shelby County versus Holder. In that case, the court did not strike down Section 5 per se, but the court invalidated the coverage formula. essentially the trigger for applying Section 5 to specific jurisdictions. Alabama was formally covered by Section 5. It met the requirements under the Section 4 coverage formula. So what the Republican-led legislature said in response to the concerns about the percentages of majority-minority districts is that it was simply following the dictates of Section 5. It's now not in effect, but at the time that the legislature was drawing these districts, it was. And so the Republican-led legislature is saying, we're only following Section 5's requirement that we do no harm to minority voting power. Section 5 has an anti-retrogression principle, which means that you cannot make minority voting power any weaker than it already is. You must maintain the status quo if you're in the process of redistricting or in the process of making any change to voting whatsoever. So the argument is that by maintaining the same percentage population of black folks in these majority-minority districts, we are maintaining the status quo. But if you know anything about statistics, and if you know anything about the way in which voters vote and the coalitions that can be formed over time, and the way minority voting power is exercised, you know that it's not simply a matter of percentages. It's not simply a matter of maintaining a strict formula of percentages in any given district. So what the two petitioners in this case are arguing is that the Republican-led legislature here deliberately packed minority voters into majority-minority districts. That they, and the facts bear this out, that in districts that were between 29 to 50% minority, which means less than a majority of the population, in 29 to 50% majority, black populated districts, 70% of those districts were repopulated into these majority-minority districts. So essentially, the legislature, when creating this new districting plan, grafted those voters and put them into majority-minority districts. The effect of that is to concentrate minority voting power into fewer districts, right? To remove them from other districts where they could form coalitions, where they may not form a majority, but they can, in fact, form coalitions with other voters and exercise greater power to elect candidates of choice. So that's the essence of the controversy here and why these two petitioners are making the argument that this was an intentional racial gerrymander. And there are a few interesting points about this case. One is that this is the first time that the court will discuss the Voting Rights Act at all since Shelby County versus Holder, right? So everyone's eyes will be peeled to see if the court gives any indication as to, one, the constitutionality of Section 2, which is the remaining powerful tool of the Voting Rights Act that African Americans and other minority voters have to rely on now that Section 5 is ineffective. And also what it has to say about Section 5. As I mentioned at the outset, Section 5 has not been invalidated per se. It's only the coverage formula. So to the extent that the court says anything about the continued viability of Section 5, that will be an interesting bellwether as to whether pending legislation to revamp the coverage formula will be viable or not. So this will be an interesting opinion to read just for the tea leaves of it all to see what it indicates about the future viability of both of those provisions of the Voting Rights Act. But in addition, this is the first time since Lulac versus Perry, a 2006 case where the court decided amid the mid-decade redistricting case out of Texas, this will be the first time that the court actually deals with a racial gerrymander. Right, and in that case, it went right down party lines. We had the interesting nuance of having Justice O'Connor in that case writing a separate concurrence. She's obviously no longer with the court, and the court has changed in its composition. So this will be the first time that this court is opining on a racial gerrymandering claim. And before that, it used Easley versus Cromartie, which Jeff just mentioned. So there are a number of different ways in which that doctrine can develop here. A second point that I think is of particular interest here is that one of the defenses to this line drawing, as I said, is that we were simply trying to maintain the percentages of the 2000 redistricting plan. Now, it's interesting that claim is being raised by the Republicans because they also challenged those same percentages back in 2000 when those initial districts were drawn by the Democrats. So they're now trying to use as cover the very districts that they opposed 10 years ago. So that's an interesting nuance to see. The other issue is one that I mentioned before, is that in the context of Section 5's anti-retrogression principle, this doesn't necessarily seem problematic on its face. But again, I think if we look at the numbers, the fact that these current majority-minority districts in Alabama are at 65% black populated, right? So these are overly packed districts. Some of them are packed up to 77% with African-American voters. Those voters can certainly be put in other districts to have broader voting power and exercise broader influence in the outcome of elections and a broader opportunity to elect minority candidates of choice. The NAACP Legal Defense Fund, where I work, we filed an amicus brief in this case, and one, we wanted to reaffirm the principle that majority-minority districts are an essential component of the Voting Rights Act and that they ought to be protected. And we also wanted to emphasize that compliance with Section 5 is indeed a compelling governmental interest. So that is one point in which we all agree that it is a compelling governmental interest to comply with Section 5. The argument, though, is that the legislature here did not comply with Section 5 accordingly. That instead, what was really required was an inquiry into racially polarized voting, an inquiry into common interests among voters, an inquiry into voter turnout. How do, in fact, minority voters vote? What is their electoral power in Alabama? How can we construct districts that do not dilute their voting power? And our argument is the way to do that is not to pack them and over-concentrate them into a smaller number of districts. So it'll be interesting to see what the court does with this case. If you're asking for predictions, I certainly don't think this is a case that will be based on a unanimous decision. That would be quite unlikely. I should mention that there's also a standing question in this case. It's possible that the court could decide on standing grounds. The argument there is that the two organizational plaintiffs don't have standing, that there ought to be some individuals in the districts who present these claims. I don't know that the court will go this route. As I said, what'll be most interesting is to see what the court has to say about the Voting Rights Act in light of the recent attack on Section 5 and the remaining hope that is placed on the efficacy of Section 2.
That was just great. Let me just press you one step on the predictions. As you said, the crucial question is what happens to Section 2 and Section 5. For Section 2, the last time we heard from the court, Justice O'Connor in Bush and Vera went out of her way to write a separate concurrence to her own opinion, making clear that she believed that Section 2 was constitutional, even though her conservative colleagues suggested it was unconstitutional. Pam Carlin had the great line after that, that at last Justice O'Connor has found someone she can agree with, herself. But Justice O'Connor is now replaced by Justice Alito, so A, will the court overturn Section 2 of the Voting Rights Act now that Justice Alito has replaced Justice O'Connor? And B, might the conservative justices be sympathetic to the intentional racial discrimination claim under Section 5, because they generally are sympathetic to claims of intentional racial discrimination?
That's right. Let me take the latter question first. I think what's another interesting nuance in this case is that it seems as if this is a case of racial quotas, right? Indeed, the judge below this came up to the court from a 3-judge panel, and Judge Myron Thompson, who is the lone African-American judge on the 3-judge panel, said that to the extent that the legislature was replicating these percentages, this was in effect a racial quota. It was essentially saying we must include the same numbers, or at least the same percentages of African Americans in these districts in this plan as we did in the previous plan. And that smacks of racial quotas, and I do think that that will be an affront to many of the justices who would not otherwise be as sympathetic to these sorts of claims. So this is quite ripe for I think, broader consensus on these issues. In terms of the constitutionality of Section 2, we firmly believe that there are many grounds on which Section 2 can be upheld as constitutional. I do not think that this court, after gutting Section 5, is prepared to do any damage to Section 2, and the court does not need to reach that issue. That is not before the court. The court can decide this issue without touching Section 2, and that is exactly what the court ought to do if it is limited in its reach as it ought to be.
Wonderful. Greg, there are many cases that remain, all of which you can shed light on. Can I just presume to? No. I'm gonna just ask you to. I'm gonna pick one that I'm interested in, which is Hine versus North Carolina. Can an officer's mistake of law provide individualized suspicion to justify a traffic stop? Tell us about that one.
Sure. Well, first of all, to give you an indication of the momentous nature of the cases on the court's docket at this point that we're now into talking about the cases I'm going to talk about. But they're very interesting cases. And the Fourth Amendment area is one of the more fascinating areas on the court, because it's one in which the justices don't tend to fall into conventional lineups, and one in which I think the Roberts Court is quite different than, say, the Rehnquist Court. And there's been a lot of development in that area in the past 10 to 15 years. And in my view, there ought to be a rule that there's at least one Fourth Amendment case in the docket each term, because they're so interesting. And we're fortunate enough that there is one Fourth Amendment case, and it's the Hine case. So Mr. Hine was actually asleep in the back seat of his car when his vehicle, which is driven by one of his friends, was pulled over by a police officer because it had a broken rear brake light. The police officer believed that under North Carolina law, that just like anyone else who's seen many TV shows, we know that police like to pull cars over for not having a broken taillight, and he thought it was against North Carolina law to have a broken taillight, when in fact it turns out, and we'll talk about this a little bit later, that actually under North Carolina law, it's okay as long as you have one taillight that works. You don't actually have to have both taillights that work. Who knew? But that's the law apparently. So the vehicle was pulled over. The police officers thought that the occupants were acting rather nervously and asked Mr. Hine if he could go ahead and search the car. Mr. Hine said he didn't really care. He should have cared, because the police officer found a bag of cocaine in the car, and he was arrested for possession. He and his colleague were arrested for actually trafficking in cocaine. But they challenged the search on the grounds that the police officer lacked reasonable suspicion to pull him over at all for the traffic stop, because he had made a mistake about what North Carolina law required as to the taillight. And so it's a very interesting question. I mean, it's settled in this area that police officers can have reasonable mistakes as to facts, and as long as the mistake was reasonable, that could supply reasonable suspicion. So the question is, well, does it matter when the mistake is to law? And Mr. Hine makes several interesting arguments, the lead one of which is that ignorance of the law is no excuse. And if it's no excuse when it comes from the defendant's perspective, it certainly should be no excuse when it comes from the law officer's perspective. And that's particularly true given that the law officers, when they're out on the roads and decide to conduct traffic stops, are incurring liberties. And so at a bare minimum, we ought to expect police officers to know the law. We ought to demand that they know the law. These aren't the sorts of things that police officers should be making on-the-spot judgments in the field on what the law is. They should know it when they get in their police car and hit the roads. And so therefore, the court ought to say that a reasonable mistake of the law is not a basis for supporting reasonable suspicion that the search was unlawful here. The state of North Carolina disagrees with that and is supported by the United States. Their position is that the whole sort of touchdown tone of the First Amendment is reasonableness. And that provides flexibilities for the officers in the field in making judgments, and that just as long as the mistake is reasonable, and here the one thing everybody agrees with is that the police officer's mistake about what North Carolina law required was actually reasonable, then it doesn't matter if it's a reasonable mistake as to law or reasonable mistake as to fact, it can support reasonable suspicion to do the search. The government also points to decisions from Justice Marshall and Justice Story going back a long ways, treating a mistake of law as a basis for finding probable cause. And they talk about the practical difficulties of the police officers in the field and the like. One other interesting dimension of this case is there's a lot of debate about whether this question of the reasonableness of mistakes at the law should go to the question of whether the search, the stop was valid in the first place, whether there was reasonable suspicion to stop the car, or whether it should go to the question of remedy under the application of the exclusionary rule, even if one concluded that the officer lacked a reasonable suspicion to pull the car over and allow the events to proceed, maybe one would take into account the reasonableness of the mistake of law at the remedy stage and find that it should be not excluded in terms of the evidence that they found. So, I think that the arguments shape up as very stark views on the meaning of the Fourth Amendment, the case law in this area going back to the times of Justice Marshall, and the practical realities of how officers operate in the field. So I think it'll be very interesting. Last term, the court had a bunch of Fourth Amendment cases, including not only the cell phone privacy case, but one dealt with the question of whether or not police officers could rely on an anonymous tip that someone saw a vehicle that they believed to be driven by someone under the influence of alcohol. And the court divided 5-4, with Justice Thomas writing the decision for the court, writing that it was reasonable to rely on the anonymous tip that supported the police officer's decision to go pull the car over, and Justice Scalia writing a vehement dissent that the court had served up what he called a freedom-destroying cocktail for police officers to go out and pull people over and deprive them of their liberties on the road. So I think that this case will be very interesting in terms of how the court reacts to it.
Freedom-destroying cocktail sounds sort of delicious, actually, so I wouldn't mind one.
For some members of the court.
We have exactly. We have 20 minutes. I want to leave time for questions, but we have just 3 small questions to discuss. First, which is the future of marriage equality and the future of contraception and the Affordable Care Act. So let's be as efficient as possible. Greg, I'm just going to use moderator's prerogative and say, sum up what should we be looking for on September 29th when the court considers 7 petitions in marriage equality cases? These are all from circuits that have struck down bans on marriage equality, but the Sixth Circuit is about to decide, and some people think it might uphold the bans. Without a circuit split, why does everyone seem so convinced that the court may well take the cases this year, and what are some of the considerations that may drive the decision?
I guess we ought to be looking for white smoke to be coming from the court building that day or something like that. No, it's very interesting. I mean, the court has 7 petitions before them that they'll consider at that conference. And one of the things that is unique is that the respondents in these cases, all of whom won favorable judgments below, validating the laws governing same-sex marriage, all agree that the court should take the cases, but they disagree about which case the court should take and what the better vehicle is. And so there's a lot of sort of squabbling among the lawyers about which case is the best case, which is interesting given that usually the strategy on that side is to sort of say, don't take my case, leave the decision intact. But I mean, the justices have difficult decisions to make. It seems, I think inevitable and unavoidable at this court for the court to pass on all those decisions, particularly when they know that there are other cases in the pipeline. But then the question becomes, which case do they want to take, and would they be better served by taking multiple cases? And I think they'll be looking to who the parties in the case are. There are some cases where the states and the attorney generals and the governors themselves are defending the law, as in the Utah case, where other states where the government itself is not defending the laws and it falls upon clerks of court, and that can raise some of the standing questions and other jurisdictional or jurisprudential questions that the court struggled with. For example, in the California marriage case, there are cases about recognizing different types of marriages, recognizing marriages from out of states. And so I think the court's going to have to decide how much it wants to put onto its plate. And I wouldn't be surprised if it decided to take multiple cases just to provide some insurance that as it began to work through the cases, if vehicle problems arose, it would have a backstop of additional cases to fall back on.
Sorry for keep asking for predictions, but do you think they're going to take a marriage case this year?
I do. I mean, it's hard to see them not taking any of those cases.
Emily, the contraception mandate post Hobby Lobby, what cases are on the horizon?
So post Hobby Lobby, there are a lot of cases being litigated right now in the courts of appeal about the nonprofit contraceptive coverage accommodation. So there's a special rule for religious nonprofits saying, said before August that while the nonprofit didn't have to provide contraceptive coverage directly, it could fill out this form saying it had a religious objection to providing contraception, give it to its insurance administrator, its insurance provider, and the third-party administrator or insurance company would directly provide the coverage to the religious nonprofit's employees without any cost to the nonprofit. But a lot of religious nonprofits, despite that more accommodating approach, said no, filling out the form is a substantial burden on our religion because it puts these wheels in motion that will lead to our employees getting contraceptive coverage. So it requires us to participate in this process that we find abhorrent, and if we don't fill out the form and we don't provide the coverage, then we have all these fines that are imposed on us. So a couple days after the Hobby Lobby decision, which you might remember, pointed to this accommodation and said, look, here's a less restrictive thing that the government could do for for-profits. They could provide this accommodation. A few days after that, 6 justices of the Supreme Court said, we're going to enjoin the government from enforcing any sort of penalty against this religious nonprofit, this religious college, that has objected to the accommodation rule. That the religious college doesn't have to fill out the form and give it to the insurance provider. Instead, the religious college can write a letter to the Department of HHS saying, we have a religious objection, and HHS can do something to ensure that the employees get coverage, and that's going to be the status quo while these issues are litigated below. The 3 female justices wrote a very passionate dissent saying, 2 days ago you pointed to this accommodation as a thing that was a model for how to address the needs of employees and the religious objections of employers, and now you're enjoining the application of the very rule. And why, by the way, is it less of a burden for the college to write a letter to HHS than to fill out this form and give it to the insurance provider? So there are a lot of cases fighting over those issues right now, and the nonprofit, and in August, the coda to the story is in August, the administration released new rules saying, fine, give the letter to HHS saying you have a religious objection, and we'll do it that way. So that's the current rule, but the various challenges to the accommodation are still going forward. It's not as though the religious employers have said, well, that's fine then, we're comfortable. So the Supreme Court will be either this term or next term, no doubt weighing in on whether that accommodation rule in itself is a violation of RFRA, despite its design to address these very issues, and despite what seems to me a really small burden in that you're just being asked to say, I have an objection to doing this, that's what you're being asked to do. But yet there are many cases arguing that filling out that form is a substantial burden because the ultimate result will be that the employees get the coverage.
Great. We have really 13 minutes, so very briefly, Marty, there seems to be a circuit split on the question of whether under the ACA there are tax credits for federally created exchanges in addition to state-created exchanges. The statute clearly allows it for the state, but the D.C. Circuit, in what some called an example of hyper-textualism in the Halbig and Burwell case, said that federally created exchanges were excluded. The Fourth Circuit disagreed in King and Burwell. Will the Supreme Court take the case, and how will it decide it? Marty.
I'll be very quick because I want to give you guys a chance to ask questions. And I won't go into the merits, which many of you, anybody who's interested probably knows. This is a somewhat technical question about the language of the Affordable Care Act and the plaintiffs having latched onto language that seems to suggest that these subsidies for purchasing insurance on the exchange are only available for plans that are established by the state. That's the term used in the statute. And most of the plans have instead been established by HHS. And so the argument is in any state in which it's the federal government rather than the states that have established the exchange, there are no subsidies available to the individuals who would purchase the insurance on that exchange, which would basically mean the end of the ACA, right? It would be a backdoor way, a statutory way of gutting the ACA. The Fourth Circuit and the D.C. Circuit have disagreed on this. The D.C. Circuit has agreed to rehear its case en banc. I believe the argument is in December, something like that. They will hear it in December. I think the odds are that the D.C. Circuit will reverse, and therefore there will not be a circuit split at that time, although there are other cases percolating in some of the other or the other circuits as well, so there might be a split. I think that as to whether the court will grant cert, I think it's unlikely, but possible the court would grant cert even before the D.C. Circuit rules, but I think because it only takes 4 justices to grant cert, and there may be 4 who are eager to get to this question, but I'm not sure that there are, especially if they don't know what the 5th justice will do on the merits. I think the more likely thing is, and what the court would usually do in a situation like this, is allow the D.C. Circuit to opine. I think we can safely assume that the D.C. Circuit judges will issue a series of opinions that will be very thoughtful and very provocative. There's a lot of very, very esteemed jurists on that court. And at that point, if there's no longer a circuit split, we are, another year or 2 into the ACA, more and more people having relied on that statute in order to provide them with insurance coverage that they had never been able to afford in the past. That would obviously act as, I would think, a disincentive to at least to some justices of taking the case and possibly overturning this major social welfare statute at a time when so many people have come to rely upon it. But I am really hazard to guess whether there are 4 votes to take it, and if there are, whether there are 5 votes to overturn what the Fourth Circuit has done and what the D.C. Circuit might do. I really think that it is very difficult to predict the future on that one.
Thank you for that succinct and prudent answer. Ladies and gentlemen, we have 10 minutes for your questions. Yes, sir.
Thank you. So this is primarily, I think, for Emily and Bill, although if other folks have thoughts, I'm curious. There's this other Hobby Lobby-like case called Eden Foods that's making its way up. And what makes Eden Foods unusual is that the owner of the company blabbed to a reporter that he actually doesn't have a sincerely held religious belief and that he just objects to government regulation. And his briefs say one thing, but his press statements say another. And in fact, he talked to the reporter once, and she didn't realize that his statements might have legal significance. And when she learned that they might, she called him again and said, "Hey, this lawyer told me that your statements might have this legal significance. Is that actually what you're saying?" And he reconfirmed that, yes, he doesn't have a sincerely held religious belief. Now, the courts up to this point, and Hobby Lobby was very clear on this, have said that it is not the job of the judiciary to probe into someone's belief. But I don't know of a case where someone actually goes to a national media outlet and says, the thing that I said in my brief is actually a lie. So, I'm curious as to, whether the court might create an exception to that rule here, or are they so entrenched in that view that we're stuck with what we've got?
No, the court, I think, has always allowed inquiries into sincerity. I mean, in Hobby Lobby, they indicated that they don't want to get into religiosity that much and the definition of burden or not. But there's an old case, United States versus Ballard, which suggests that you can look at sincerity. They need to look at sincerity. Otherwise, what the problem with Hobby Lobby is, even aside from some of its other circumstances, is that anybody can claim a religious belief for anything. And so there has to be some limit to it. I think one of the reasons why Sherbert was overturned by Smith, which led to the RFRA example, was that Sherbert led to so many of these ambiguities there. I think what that case indicates and what the cases Emily talked about indicate is that Hobby Lobby is a little top-heavy. And it might fall of its own weight on how much accommodation is needed and what's needed and why. And I think we're going to see maybe a reaction to Hobby Lobby similar to the reaction we saw to when the free exercise clause was given its own independent strength in Sherbert.
Thanks.
And I agree that the court definitely isn't going to inquire into the theology and whether theology actually requires this objection, but whether you're lying when you say that you have this objection, I think is still very much fair game.
Not to mention that it raises ethical concerns.
I do think, though, that it is lurking behind all of the cases. And as Emily described, as the government becomes more and more accommodating and says, okay, you were complaining about this, you don't have to do that. Now, basically, all you have to do is say that you have a religious objection and tell us who your third-party administrator is. The response to that in the 10th Circuit and probably later this afternoon in the D.C. Circuit by all of the plaintiffs has been, oh, that violates our religious conscience as well. We can't even opt out because we will be complicit in the use. At some point, the lawyers are saying that, and I guess their clients are agreeing that this violates our religious conscience. I don't think there will be deep inquiries into the sincerity, but judges are going to start to get worried that this is, by saying we can't second guess this, we're allowing them to make claims that might not really truly be based on their best views of what their religion does or does not prohibit. They won't. This is the problem with the cases.
That's great. I think we have time for one more question, if there is one. And if there's not, Adam Liptak.
I'll just talk about it. I have a question for Greg. Might affirmative action come back to the court this term?
I was hoping nobody was going to ask that. So I think Adam's may be referring to the Fisher case, which the court decided a couple years ago, and it was back on remand of the Fifth Circuit. On remand, the Fifth Circuit issued an opinion agreeing with the university that its plan was constitutional under the strict scrutiny standard as described in the Fisher decision. The plaintiff has filed a petition for rehearing with the Fifth Circuit. The Fifth Circuit is now considering that. So I think in terms of getting the case back to the Supreme Court this term for briefing and oral argument, we certainly would hope that the Fifth Circuit would deny the request for rehearing and the Supreme Court would decide not to hear it. But either way, just in terms of the logistics, I think unless the Fifth Circuit acts very quickly, it's hard to see the case getting counted this year.
Greg did a superlative job representing the university.
No,
Oh, you did.
well, thank you.
Representing the university.
That is great. Well, ladies and gentlemen, the job of the moderator is to end on time. If anyone thought that this coming Supreme Court term would be anything less than engaging and exciting, those thoughts have been dispelled by this absolutely superb panel. Please join me in thanking our panelists.